member presents an informational webcast.
Welcome to Corporate Board Members Informational Webcast. I'm TK Kerstetter with Corporate Board Member, and we have another interesting show for you today where we're going to cover the topic of antitrust in the boardroom. And we're happy to have an expert here with us to help us sort of guide our way today. Let me introduce Barry Nigro, who's the chair of Frank Antitrust Group. Barry is the former FTC Deputy Director for the Bureau of Competition. As Deputy Director, he managed the Bureau's merger and anti-competitive practices investigations and litigation. At Frank, he counsels clients on transactions, cartel investigations, and antitrust compliance matters. Barry, welcome.
Thank you, TK.
So antitrust appears to be sort of a growing topic and also a growing risk these days. So let's start by talking about, is this a trend? And if so, what's the issue with directors?
Well, thank you for inviting me to talk about this important topic today. It is a trend. The regulatory environment when it comes to antitrust and competition is at a level now that it's never been at in the history of our country. There are over 90 countries with competition laws today, and both the FTC and the Antitrust Division of the Department of Justice have units that are charged specifically with coordinating antitrust enforcement across the world. So the level of coordination, the number of jurisdictions with antitrust rules has skyrocketed. And then just here at home, President Obama, when he was running for president in 2008, made it very clear that he intended to reinvigorate antitrust enforcement, and he's done just that. There's much more active enforcement on multiple fronts, both with respect to M&A transactions and business conduct, including cartel enforcement. So the environment from a board of directors point of view is, presents a level of risk that I think is unprecedented and merits a lot of attention.
And we're not talking about just moderate risk here. These are some big issues. Explain the different areas that sort of are the focus for.
Sure. Now the risk can be substantial if it's not properly managed, and there are really three different areas that come into play from the board level. One is mergers and acquisitions, transactions. Much more active enforcement today than over the past several years. The other is business conduct. There are efforts underway at both agencies to bring much to expand the enforcement of the antitrust laws and bring cases that in some instances attack the business model of certain businesses, and this is particularly true in high tech and healthcare industries. But more importantly, the enforcement level in the cartel area has really exploded, not just in the U.S. but worldwide. And then there's some areas that directors need to pay attention to themselves, because there are specific restrictions on what directors can and can't do when it comes to serving on boards.
When I think of antitrust, I think of M&A transactions. So is that like one of the lightning rods?
M&A is certainly an active area, and it's an area that I spend a lot of time in. I think one thing to keep in mind when it comes to M&A is that, and this was true when I was at the FTC, and it's true today, most transactions from an antitrust perspective are generally pro-competitive and don't raise issues. However, those that do can really create a problem for a corporation if those issues are not anticipated and not managed. So when I think about antitrust in the M&A context, I think about the tax associated with getting the transaction through the process, and that tax has gone up. And when I talk about the tax, I'm talking about the time associated with getting through the antitrust review. I'm talking about the costs, the lawyers, the accountants, and the other professionals who are associated with with getting clearance from the antitrust agencies. And then there's the risk of actually, will the deal close, and will there be significant divestitures required in order to get that deal to close based on an antitrust review. So when you look at all of that together, it can, in cases that present antitrust issues, present a huge amount of risk and something that merits attention from the board. And there are a couple different areas that where this is, some example. I guess I can give some examples. If you think about just over the past year and a half, there have been several major transactions that have been challenged by the antitrust division itself. There's, of course, the AT&T T-Mobile case, where the Department of Justice brought a case. They brought it early in the process. Typically, with telecom deals, they've waited until the FCC has completed its review, and more often than not, those deals have been remedied with divestitures or some other sort of fix that addresses any competition concerns. In the AT&T T-Mobile case, the Department of Justice did not wait for the FCC to complete its review, and actually was fairly aggressive in filing a lawsuit seeking to block the deal based on both a national and a local market theory. And that, as you know, resulted in a breakup fee that was in the billions of dollars. There were also issues with NASDAQ, New York Stock Exchange. The antitrust division was very, very aggressive there. H&R Block Tax Act case, where they obtained an injunction blocking the deal. So the risk associated with getting deals that raise issues through the agencies is a lot greater today than it was just 3 or 4 years ago.
And is there other areas, I mean, M&A is, and again, those kinds of situations, is there other criminal or other things that boards should be aware of?
Before I talk about criminal, I just want to mention business conduct, because the agencies, both the Antitrust Division and the FTC, have been much more proactive in bringing cases that challenge, in some matters, the business model of the corporation. And you can look at the Department of Justice's case against American Express, or the case against Blue Cross Blue Shield challenging most favored nations provisions in contracts. I mean, those are fundamental business models that are under attack. But the area that raises even greater risk is cartel enforcement, and there the Antitrust Division in particular has consistently been very active and very aggressive in enforcing the antitrust laws when it comes to price fixing, bid rigging, market allocation. Those are the areas where there's criminal risk. And the penalties are substantial. We're looking at a statute that allows for a $100 million penalty per offense against corporations, $1 million per offense against individuals, and 10 years in jail. And you say, well, white-collar criminals don't go to jail. They do. The average jail sentence for a business executive convicted of price fixing or market allocation is in excess of 2 years. And in the most recent case that was litigated by the Antitrust Division and won in the trial court, the division sought a 10-year jail term and a $1 billion fine against the defendant. And you say, how did they get a $1 billion fine? Well, there are alternative sentencing statutes that apply that allow the division to seek penalties that are in the range of double the gain or loss associated with the offense. So we're talking about substantial sums of money. Just in 2012, the total fines collected by the Antitrust Division exceeded $1 billion. That was more than double what they collected in 2011, and that was based on fewer cases. I think in 2011 they had close to 100 cases. In 2012 it was around 67, and yet the fines doubled the total in 2011. So the risk is substantially greater today than it was in the past.
And none of these penalties or fines count all the lawsuits that follow subsequent lawsuits when a company finds itself, subject to these penalties, correct?
Absolutely. I mean, any time that you have a criminal investigation, I guarantee you it'll be followed by civil lawsuits, treble damage lawsuits. So you take the $1 billion fine and you follow that up with multiple class actions. The total cost of the company can be in the billions and billions of dollars. And in addition to individuals, senior executives going to jail and actually serving jail time.
Talk about the directors themselves. Are there any antitrust issues that sort of affect them, sort of on a direct basis?
There are. There's some very specific restrictions on directors and actually officers and directors that govern what boards they can sit on and how they conduct their business. There are really two statutes that apply. One is Section 1 of the Sherman Act, which is the same statute that prohibits price fixing, market allocation, and bid rigging. There's also Section 8 of the Clayton Act, which specifically prohibits interlocking directorates. And by that I mean a director, like yourself, cannot sit on the boards of two companies that compete with each other in any way. So most directors know that they can't sit on the board of company A and also sit on the board of company B if A and B are each other's principal competitors. But what a lot of directors may not know is that if those two companies have multiple lines of business and they overlap or compete in just one small segment of one of those lines of business, they have an issue that needs to be managed under both Section 1 and Section 8. In fact, under Section 8, unless they fall within one of the exemptions, they may not be permitted to sit on the board of the competitor at all, even if the overlap is modest. So those restrictions apply specifically to officers and directors. They also apply in situations where a firm, and this comes up a lot with private equity investors, appoints two different individuals on the boards of those two companies, company A and B. Because those individuals are representatives of the investor, the private equity firm, under the law, at least in the view of the Department of Justice, they are deemed to be the same person, and that raises issues as well. So all of those things need to be managed in a way that makes sense and avoids a problem, because the problem could be the criminal or civil liability that I talked about before, or the director may have to withdraw from the board on short notice, which is not a good outcome.
Barry, we have about a little over a minute left, and I want to make sure that we touch on sort of advice that you have for directors around the space so that they can, not fall victim to, some of this. So what advice would you give our viewing audience out there as far as tips to sort of do this the right way?
Well, there are really three things, TK, that I would do as a director. One is to make sure that the company has an effective antitrust compliance and risk management program in place, and it needs to be effective. It doesn't help to have something on paper that's not actively promoted within the company. Secondly, in connection with any transaction, no matter how large or small, I would make sure that somebody has done an antitrust risk assessment, because the agencies have brought cases just in the past year challenging deals valued at $2 or $3 million. So most people think, well, that's too small. It's not. There have been lawsuits filed over challenging deals of that size. And then lastly, I would make sure I know who my directors are and what other boards they sit on.
Well, that's great advice, Barry, and we appreciate you coming. I'm not sure that you haven't opened a couple eyes when you're talking about billions of dollars and actual sentences in jail, but I think the important part here is this is something that has to be thought through in a proactive sense and not find yourself as a board in the situation of having not only fines and penalties, but then subsequent lawsuits.
Absolutely.
if anybody wants additional information, you can contact Barry by reaching him on email at barry.nigro@freedfrank.com, or go to their website, www.freedfrank.com. So Barry, thanks again for joining us, and that will conclude this session of our Corporate Board Member Informational Webcast. Please join us on our next one, where we'll take a look at another issue that'll help you be a better director. We'll see you then.
This has been a presentation of Corporate Board Member, an NYSE Euronext company.